Hello and welcome to the Bar Council's Criminal Legal Aid Billing Seminar. This is the first seminar we've done on this topic for 3 years, and we're delighted to have three expert speakers on our panel. My name is Adrian Vincent, and I, together with my colleague Rowan, provide the executive of the Bar Council's Remuneration Committee. The Remuneration Committee deals with all matters to do with barristers' money, so legal aid fees, whether it's civil, criminal, family, privately funded fees such as conditional fee agreements and barristers' taxation. Behind the scenes, we also have my colleague Angela from the training and events team, and she'll be pressing the buttons on the Zoom and pressing on the slides. We're also grateful for our colleagues in the communications and marketing team who've advertised the event. We have two of our speakers will speak on Crown Court Defence legal aid fees. The first speaker will be Stephen Kelly, who is the Legal Aid Agency's technical lead for the Advocates Graduated Fee Scheme, AGFS. The LAA, as most people know, have been dealing with a cyber attack, so it's been a huge amount of additional work for LAA staff. So we're particularly grateful that Stephen's given up his time in addition to all the other burdens. Then we'll hear from Sarah Reynolds, who's a senior practice manager at Doughty Street Chambers and is a member of the management committee of the Institute of Barristers Clerks. And the cyber attack has also added to Sarah's burdens, and she's been very kind in being a main point of liaison between the bar and the LAA over practical steps to do for the recovery. And then we'll move on to the third speaker, which will be on the prosecution fees. That's Tom Little, who's first senior Treasury Counsel and Vice Chair of our Remuneration Committee. The Bar Council doesn't give out medals, but if we did, then Tom would have received a medal for long-standing service, having first been a member of the chair of the Young Barristers Committee 20 years ago, and then on our Remuneration Committee ever since, and so is our expert on the CPS fee scheme. The format is each speaker will speak for about 15 minutes. We've already had 7 questions come in writing, so we will then move to reading out the questions and our speakers will give their answers. And then after that, I will read out questions that appear in the Q&A box. So you should see on your Zoom screen that there is a chat box and a Q&A box. Please ignore the chat box. If you have a question arising from the talk, type it into the Q&A box, and then I will read those out in the second half of the session. The seminar is being recorded, and so will go on the Bar Council's website in due course. And apparently there is a live transcription option available by clicking on the relevant button on Zoom. So I'm going to be careful not to do any swearing in this session. Let's go to our first speaker then. Stephen, can you give us your tips from the insider's view from the Legal Aid Agency, please?
Thanks, Adrian. Yeah, I have a slideshow to just go through, so we'll just wait for that to come up, and then we'll go through that with you guys. So if we could go to the next page on the slideshow, that'd be really helpful. What the intention is today is I'm going to go through 2 different aspects. The first bit is I'm going to just go through a few hints and tips of ways that you may be able to increase your remuneration. Some people will potentially know a lot of what I'm going to say, but I imagine not everyone will know everything, and there'll be hopefully a few nuggets of gold in there that will help you maximize your income in that area. And the other aspect will be for me to just touch on common platform, which I know is an issue for everyone really, and I'll touch on that and things we can do there. So just wait for the slideshow to come up, and if we could just jump to the next page, that'd be great. Brilliant. So I'll get started. So the first area I wanted to talk on was the remuneration around Section 28 hearings and the changes that were made to that area for representation orders that were dated after the 1st of February 2023. At that point in time, we introduced a new fee into the fee scheme for the Section 28 hearings. Now, that was initially set at £670 for orders that were granted between the 1st of February 2023 and the 15th of November 2023. Any order that was granted on or after the 16th of November 2023 is now payable at the higher rate of £1,000. So there's a couple of aspects with it. We do see most council will claim that Section 28 fee when they're entitled to, but not everyone. So we really want to get that message out there that that's payable to you guys. If we have a Section 28 hearing that takes place, it's payable once per case. But the other thing I really want to clarify, because I think there is a bit of confusion that I've certainly noticed, is that is in addition to the daily attendance fee that is payable for any Section 28 that takes place. So it's not either or. It's, you get the additional Section 28 fixed fee on top of any daily attendance fee that where there's been a Section 28 that takes place. So it's really good to make sure we're clear on that and make sure that that can be claimed. It can be claimed, and you're claiming both so that you're not losing money in that area. There's obviously been other changes around the additional preparation fee, for instance, from the 17th of April 2023 that was introduced, and also more, a longer time ago with the unused material for rep orders after the 17th of September 2020. We see much higher uptakes in that, and they tend not to be missed. But again, just to make sure that you are entitled to them if there's a crack trial or trial case, and obviously make sure that you do claim that money so we can get that out to you guys. So that's from the first page. If we can move on to the next page, Angela, that'd be great. So in this area, I'm just going to talk around how you might be able to maximise your fees through the indictment and the offences on there. And I'm going to go through an example of one that I'm not sure everyone would know about. I suspect quite a lot of people don't. So under the HFS banding document, high remuneration may not always align with the most serious charge. It normally does, but it doesn't always. So the example I've got today is if you have, and I've seen this example, in the past, on the indictment you have the defendant is facing a charge of murder, and they're also facing a charge of supplying Class A drugs. Now, if the murder was to fall within the standard banding of 1.3, the lowest paying banding, but you also had, for argument's sake, PP that exceeds 5,000 pages, but it could also be the qualifying weight for the drugs offence, which took the offence into the highest qualifying banding of 9.1 for the drugs offence. Now, the drugs offence in this circumstance actually pays a higher amount, except in very rare circumstances where the trial exceeds approximately 65 days for a 1.3. What actually I also didn't know about, didn't fully realize until I was researching this, is the 1.2 banding for murder, one of our higher banding paying murder offences, that also actually pays less than the 9.1 in most circumstances. Now, the tipping point into where a 1.2, if it was a trial, would end up paying more is at a lower stage. It's around about 65 days for a 1.3. Whereas if you're looking at a 1.2, it's around about the 33-day mark. But it's a really good thing just to be aware of that, and to review that. So, given an example just of a standard 10-day trial for a junior counsel, the BAM 1.3, if it was claimed, would pay £8,964 plus VAT, while a BAN 9.1 pays £12,229 plus VAT. So we can see there's about a £3,500 difference that you may not be aware is available to you. So really a good bit of advice I can give is on the gov.uk website. If you would just type into Google HFS fee calculators, you are able to model these things. The calculators are readily available and you can have a look around. So if you have multiple offences on the indictment, I would suggest having a little look at that. and not maybe automatically assuming that what may be would be the more serious offence necessarily pays the higher banding, because you may be missing out on money by doing that. There is some other examples of this that I've seen in the past. A good example may be if there was an armed robbery with a firearm, but there was also a firearms offence on the indictment. Quite regularly, you'll see that claimed as armed robbery, but generally speaking, the firearms offence, if it was a 12.1, would pay a higher banding. So, like I said, this is not the only example, but it's the one I've used to just highlight it today and see the level of discrepancy in money. So, definitely would advise have a look on the online calculators if you're unsure, and that will give you the best outcome that you can claim, so we can review that for you. If we could move on to the next slide, that'd be great. So the third slide here, I'm just going to mention a few cost use decisions. A lot of people may be aware of these, but again, I imagine not everyone is. So I just want to touch on them and ways that you may be able to increase your remuneration if you're not aware of it. So the first one is R versus Simmons and others. So in this case, it was a multi-handed murder case in which one of the defendants was aged 16 and all of the co-defendants were aged over 16. The wording in the banding document says if the defendant was 16 or under, but the cost judge made clear that every defendant in a circumstance of a multi-handed murder where all the defendants are charged on murder, everyone should get the remuneration of the 1.2, not the defendant that was not only the defendant that was age 16 and hit the criteria. So that's something we've followed since that cost judge decision. Most council tend to claim that, but again, it can be missed, and there's a significant increase in your payment if you were to claim the 1.2. So I would advise highly to do that. Next, we've got the decision of Arvis Collier. So this was for an historic indecent assault offence under Section 14 of the Sexual Offences Act 1956. Within the banding document, that's specifically classified as a band 5.2 and doesn't have any wiggle room. But again, that went before a cost judge. The specifics of the offence was that complainant was a child at the time of the incident, and the offence involved penetration. Cost judges said in that circumstance we need to be paying a 4.1. Again, we're fully behind doing that in those circumstances. So if you have an example like that, please make sure to claim the 4.1 there. That's the same for pretty much any sexual offence that has penetration. We will look to consider that as a 4.1 if we can confirm that, so that's a good thing to know and a good thing to be claiming. The next one, just maybe more for information than anything else, are the Avocus and a bonus, is that if it's a cannabis case where there is an estimated weight range, we would look to use the median based on that cost judge decision. So we obviously would go to the lower end, but we also don't go to the higher end. We go in the median based on that cost judge decision. And the final one I've put together is a cost judge decision of R versus Avery. This is in relation to defendants being charged with intentional strangulation under Section 75A of the Serious Crime Act 2015. That's an unclassified offence within our fee scheme, and I've seen it claimed in lots of different ways. The cost judge has determined that 3.4 is the most appropriate banding. We see lower bandings from time to time, 3.5, 17.1. So I'd advise to claim that as a 3.4, and yeah, that is certainly something we would look to accept on that basis in line with the cost judge decision. If we could move on to the next slide, that'd be great. So the final slide here is just to discuss issues and challenges that we have with Common Platform. I want to be straight up and honest with everyone on the call. I know that there's a massive amount of challenges with Common Platform, and it's certainly one of the biggest pressures in my job to try and resolve that. And I can only imagine the issues it has for you guys. I appreciate it's far more pronounced for you than it is us, because it's affecting your pay, and we need to try and get it resolved. I wanted to make everyone just a little bit aware of what we can see, what we can't, and what we're doing in the LAA to try and improve things, because I want you to know that it is certainly probably my number one priority is to work as closely as I can with HMCTS to get this problem solved as much as we can. The first thing that I'd like everyone to be aware of is the LAA don't actually have access to Common Platform. Just so you're aware, we don't have full access. A small number of our more senior caseworkers have a small degree of access to Common Platform. I'm one of them, but we can't see the vast majority of the information we would need to see. I can't see any of the hearing logs, any of the recorded attendances, any of that is restricted to caseworkers from the LAA. What the LAA has is we are pulling data from the common platform source into an LAA specific system. So we would then be able to see the event logs, council's attendances, etc. through that. Now, we know there's quite a lot of challenges that are coming about from the common platform and the information we can see in our internal system. The two major ones at the moment we're dealing with is council's attendance not being recorded on the court log. That's a really big, a big example we see all the time. And I know that that is not just because, council, occasionally everyone will forget, we're all human. I know that there's far more at source there than that. We can see the difference in our data between what we were seeing in legacy exhibit systems compared to the amount of failure demand that we're getting from the common platform, to know that there's more issues at play than just people forgetting. That there's something going on in the system, and we are working quite closely with excuse me, working closely with HMCTS and my colleagues that deal directly with them in the LAA to try and deal with that. One of the bits of work that actually happened last week was I collated a lot of cases where attendances were missing. I have fed that back to our colleagues that manage relationships directly with HMCTS to get them to have detailed discussions and look at each one of them so we can try and understand what is causing the issue here. Is it a problem at common platform source? Is it a problem with us pulling all of the data? We need to fully understand what's going on there. The other thing we notice quite a lot is that we have quite a lot of hearings where the records just are blank. They're not that there's no data showing for the hearing. I completely understand how frustrating this must be for you guys, and it's something, like I say, we need to improve on. There is a few things that you could do that will help us while we're trying to improve that with HMCTS. The two things that we would be really helpful is, if firstly, I know that there'll be occasions where you're aware in court that there is problems with common platform. If you can flag that to your clerks that that's the case and they can advise that on submission, that's really helpful for us to go straight to HMCTS on it, and also for my colleagues to flag it more widely with me so I can have those conversations and try and get those cases to be looked at to understand what the problems are. And then the other thing that is really helpful for us, we know that attendances are not being recorded, is if you do keep a note of attendance notes for the hearings, and if you could just sign or annotate that for yourselves so we know it's your note, that just makes things a lot more simple. We need to be driving this down, so we don't need to be asking you this as much as possible, but even until we're able to do that and get the issue sorted with common platform, it would really help us if you do have those attendance notes, so we can try and make payment based on that, so we can get the money that you're due out to you. So that's everything I had for the presentation today. I believe Sarah's up next, so I'll pass back to Adrian.
Thank you very much, Stephen. That's very helpful. And now invite Sarah to tell us her experience from the clerking side.
Evening, everyone. I'll try not to cover too much of Stephen's ground, but there are some things that I will echo because they are incredibly important. But if we could go to the first slide. So hopefully I'll highlight a few ways that you can get a little bit more from your claims to the LAA. Firstly, with this slide, I'm not sure everyone's aware that you can submit your main hearing separately to the sentence if there's more than 4 weeks between the two taking place, which seems to happen more and more with the Crown Court delays that we're experiencing. So you can put your trial in and then your clerk can do a supplementary claim for the sentence and any other additional items. From my experience, the preparation claims are often dealt with by a separate caseworker, depending on the size of them, perhaps. So it's not the worst idea to separate the preparation out, because if you're redetermining attendance or specific items, those messages can get lost whilst the preparation is being dealt with. So it can be a good idea to separate those out, and then at least you'll get some payment coming in before the case is actually completed. Next slide, please. as Stephen commented about different types of offences, obviously the drugs and dishonesty offences throw up the most problems when submitting claims. On this slide, you can see that the banding of the drugs and the dishonesty offences and how they're set out. You need to provide your clerks with evidence to support the offence band that you're claiming under, particularly for these, also for sexual offences, or anything where there's one option or another. Sentencing notes, opening notes, statements, forensic reports can all assist here, as well as if you're claiming under the pages for drugs and dishonesty, the legal aid report, which you can find, which your clerk can find on the DCS record, send that with your claim. And that will help the LAA to find the information they need and assess it correctly the first time round. As Stephen has said, check all the counts on the indictment to see which one gives you the best fee. There is an app you can download as well as the calculators, which calculates it all for you, and it's brilliant. I've got some details on the final slide of resources that you might find useful. That's one that's on there. Next slide, please. So what your clerks need from you, again, I will reiterate that confirming your attendance is the thing that takes up most of my time when I'm billing and doing redeterminations alongside everything else. So if you can sign in either through a common platform or Exhibit, if it's still in use, please do. Be careful when relying on the court clerks to sign you in. I know on long trials, they may say, oh, don't worry, we'll sign you in. I've had instances where the court clerk has changed person halfway through the case, and the person who took over didn't realise the first clerk was signing their barrister in. And so they'll come back and say, oh no, well, it's counsel's responsibility, not mine. Doesn't matter what the other clerk was doing, not my problem. And they're right. It ultimately it is your responsibility to make sure, if the system is working, that you can be signed in. And as Stephen said, if there are issues that you're made aware of, let your clerks know so that they can flag it on the claim. As you'll see here, common platform, the court staff can't make amendments retrospectively. So with Exhibit and the court records previously used, they could make amendments, but they can't with common platform. So they can't go back and sign you in after the hearing's taken place. Make sure you have attendance notes and, if possible, add a sidebar note to the DCS record as well to confirm that you were there. You need to do it for you personally. So leaders doing it, juniors doing it for leaders. You're not going to be helping your leader out necessarily because it's your name and not theirs at the bottom. So make sure you make the point that you're both there. Travel expenses, make sure that receipts are provided for train journeys out of London and overnight accommodation if prior approval has been granted. The limits have increased a tiny bit, although still woefully inadequate, but they have increased to £100 including VAT for the hotels, and £25 from 21 for evening meals. If you are unable to find accommodation within those limits when you're looking, then take a screenshot of booking.com or whatever you use to show that there isn't anything suitable within the location of the court. Your clerk can try and get you a higher rate, and that does work. I've managed to do it on many occasions. Breakfast and lunch are not claimable. It's only evening meals and only when you stay over. And credit card receipts, bank account screenshots, anything without a breakdown of what you had for your evening meal are not sufficient proof of expenses either. Next slide, please. Just a bit more on travel expenses. So I'm sure you're all claiming travel when you're allowed, but it's worth noting that particularly if there's a local bar between your start point and the court, then you can claim travel from that point. So my example here, if you're travelling from London to Hull, then you could claim your travel from Leeds to Hull, as that is Hull's local bar, and that would be 77 miles each way, or the equivalent train fare from Leeds to Hull, but no overnight, obviously. You put your train tickets in, explain that you're claiming from the local bar, and the legal aid agency will give you the equivalent train fare or mileage. There's a spreadsheet that sets this out. It hasn't been updated for a little while, but obviously distances don't change. So again, I've put a link to that in my final slide so your clerks can see where you might be able to claim travel from if you haven't got prior authority and there's a local bar that's nearer. You can also claim, there's two mileage rates, 45p per mile and 25p per mile. There are some instances where you can claim the higher rate, as I've said here, if there's accessibility issues or the need to take an overnight bag or a large amount of papers. Your clerk will need to state the reason for the higher claim, so they need to know that information as to why you want to claim it. And also you can claim travel expenses and travel time when attending prison conferences and site visits. And that would be even if the conferences that you can claim for, if you've passed that threshold, you could still claim for the travel, even though you can't claim for the conference itself. Next one, please. Prior authority, not easy to get every time, but it's not impossible. We're finding there's lots of last minute returns out there due to availability. That's going to mean that the solicitor wasn't able to find suitable available local counsel. If they can provide you a letter confirming that they tried and were unable to find suitable local counsel, then the legal aid agency would consider your application. Also, if the defendant and solicitor are located outside of the local bar, you've got a case in Stoke, for example, but both the client and the solicitor are from London, that would be a reason that they would consider granting it, as well as the specialised knowledge and move their case moving courts and everyone having to travel with it. Next slide, please. Preparation. So this is one of the newer additions to the claims, and it's the ability to claim for considering unused material and also for considering served evidence in excess of the thresholds that have been set for each offence band. Starting with the unused material, this is claimable on crack trials and trials. The first 3 hours are a fixed fee, which are always claimable. That's £67.50 for juniors, £97.57 for leading counsel, and £128.93 for King's Counsel. After that, you would need to provide a work log for the hours over 3, set out the item that you reviewed, the date considered, and the time spent. The example below I've taken from claims that my barristers have put in, and they're essentially using the DCS breakdown of items as a template to fill in the details of how long they spent looking at the things and when. It's not always required a work log, particularly if the claims are sort of under 20 hours. If they're over that, then you will, not a work log, sorry, a note for taxation. Work log's always required. The note explaining why you needed to spend so much time on it may be needed if you're claiming over 30 hours and it's not necessarily obvious why you've claimed that much time. If you spent inordinate amounts of time on particular items, the LAA will need a bit more information as to why you've done that. As Stephen has said, they don't have access to the papers that you have access to or the records that you have access to, so you can't assume they know what you're talking about. So give them as much information as you can, and that will help to get the claim through the first time. Next slide, please. Special preparation, as I said, there's another option, and that's for excess pages. So you'll see on the right here, this is the threshold of pages on each offence band. And once the statements and exhibits have exceeded those thresholds, you can claim for preparation for considering that evidence in excess. If it's electronic evidence, phone downloads, things on egress, for example, no one has access to those at the LAA, and your clerks won't have access to them either, more than likely. Only you have the logins for egress, etc. So please download those documents and send them to your clerks, because they will need to send them to the LAA for them to review. The page count threshold on drugs and fraud are different and they're not included here. So they're 15,000 for drugs cases and 30,000 for fraud. Another special prep claim that you can make is for novel or unusual law or fact. And the justification is there. They're rare, but they do come up from time to time. It does have to be very novel and unusual, generally, not just novel and unusual to you. And please make sure that when you're putting these work logs in, you provide the justification to go with it, but also that you reflect the time actually spent on your work logs rather than average calculations. They need to see what you've been looking at, how long for, and when. Next slide, please. So wasted preparation is another place that perhaps people don't remember. It's easy once the case is out of your diary to forget about it, but worth putting them in because they're rarely rejected if you meet the criteria. And again, due to listing issues, it's quite common that cases are being fixed when counsel aren't available. So if that's happened, or if you're professionally embarrassed or sacked or have to return it for another reason to do with public duty, you can put a claim in, provided that the trial lasts more than 5 days, or if it cracks, the page count is over 150. And again, more work logs are needed for this as well as the relevant form that goes with it, which I think is SP1, but Stephen will correct me. So this can be downloaded. Your clerk can download it when they submit the claim and send it off. And it can also be downloaded online as well from the LAA website, but just make sure it's the correct version because there are two that are guided by the representation order date. Ideally, counsel should be completing this form, filling in the boxes with the relevant information, but they can also be submitted along with a work log and a note if that's the way the information has gone to the clerk. Change isn't always easy with these sort of processes, so in my eyes, I'd rather encourage counsel to submit in whatever format they prefer, rather than not at all. So it's up to the individual chambers how they wish to deal with that. Next slide, please. Okay, so here's some other bits and I won't go on too long, so I'm starting to get to time. But there's some things here, again, that may be being missed. Preparatory hearings, mainly on terrorism cases, but if the judge deems it a preparatory hearing, you can claim a refresher fee. Section 28, Stephen's done. Ineffective trials now, if the trial has been deemed to have started, day one's taken place. Any trial day listed after that, irrespective of what happens at the trial day, can be claimed as a daily attendance fee rather than trial not proceed. Discontinuances, I think these perhaps don't get picked up as much, but if the case gets discontinued before PTPH, you can claim a fee. And if papers have been served, any papers, a few witness statements or an exhibit, that's papers. If you can send a copy of the LAA report with the claim, then you can get a guilty plea fee. Quashed and stayed indictments are all but gone now, really, but there are the odd occasions where a whole indictment is quashed or stayed. If it's done on a separate day to the main hearing, and usually it's not, but if it is, then there's a brief fee you can claim there. Fitness to plead, if the defendant's unfit to plead, then the whole fee can be claimed as a 5.3, which is adult sexual offences, or the original offence, whichever is higher. And the fitness to plead hearing can be added to the overall length of the trial of fact. Mitigation of sentence, as you see here, there is an additional mitigation of sentence fee, and you can also claim reasonable preparation. The one that even I, after all my years, didn't notice straight away when it went into the regulations was that if hospital orders are imposed, if it's a Section 41 hospital order, then the whole case can be claimed as a 1.3 if that's higher than the offence on the case. And if any hospital order is imposed, then the sentence fee will be uplifted to a daily attendance fee. proceeds of crime. I've put a link again to the claim form in my final slide. The fees increase if the page count for the POCA pages served, only those, are over 50. And that goes up from between 50 to 1,000 pages. There are different levels of fees that you can claim for the main effective hearing. And for those that remember them, there are still opportunities to put red corner claims in for commitals for sentence and appeals in the Crown Court only, and interlocutory appeals, but they don't come up too often either. But if their committal for sentence and appeal is more complicated than the average case, and you gauge that, well, I gauge it by about 8 hours preparation or a multi-day hearing, then we can put it on an ex post facto claim. Again, work logs and notes are needed. They don't pay quite as well as they used to, but they pay better than the graduated fee scheme. And ultimately, the assessment is based on reasonable remuneration. So if you don't feel it's reasonable, then it can be appealed. And then my final slide is just those resources. These are all going to be sent out to you, so you'll be able to get them. And there's a picture of that Crime Fees app there, which I do recommend you download if you haven't already. And that's all from me. So over to Tom for prosecution.
Thank you very much, Sarah. So Tom, for the prosecution fees.
All right, thank you very much, everyone. There will be an element of overlap because there are similarities between the two schemes, although there are fundamental differences between the schemes. If we could just go on to the next page so it's clear what I am going to be talking about. I'm obviously talking about CPS fees, not serious fraud office fees, which recently increased by 25%. And there are 4 aspects to what I'm going to talk about. So if we just put that last bullet point up, then I can just say where I'm going. The existing fee scheme, really, rather than schemes, although there's the VHCC scheme. How to maximize your claims. So I'm going to give you Tom's top 12 tips. Approach to take in the event of a dispute with the CPS about fees. And I will just say something about the procedure, but more importantly, the importance of not just always taking the CPS's word for how their fee scheme works, because they're not always right. And in fact, there's an appeal procedure that I'll come to, but before you get to the appeal procedure, it will have been escalated higher up in the CPS and correction is normally made. People often just don't want to go through the hassle. You're busy, I understand that, but it's worth it because not only will you get paid, but it's more likely in the future that somebody else won't get underpaid as a result. And just very briefly, I'll deal with the future. So if we could go to the next slide, and the existing fee scheme, it's been in place now for 2.5 years, really. Applies to all hearings in existing and new cases. And the next bullet point, this won't apply so much now, but part heard hearings or resumed in between were paid under a sort of hybrid. And then the last bullet point, what it represented, you may recall if you were practicing then, that quite often then and before, increases in the CPS fee scheme have often been as a result of some increases in the defence fee scheme, a slight sort of tit for tat increase. The idea was to create an element of parity. There will never be parity because the schemes are different. People often point out that some of the defence cases pay more, and they do, but there are cases where you get paid more prosecuting, and so it's unhelpful just to highlight those where the discrepancy is one way. There are discrepancies the other way as well, and also for good reason. Plainly, if you're prosecuting a 6-handed case, that is going to be more difficult than the person who's defending in those cases as a matter of generality. So there are differences between the schemes, and the approach of the Bar Council, I've been responsible in part for this, has always been that they should not be identical schemes because they cannot be identical schemes. That doesn't mean that there don't need to be changes. If we could go to the next slide, please. And again, all the bullet points here, please. really three places. The CPS website tells you all you need to know about this. The manual of guidance is detailed. There are no cost judge decisions in the same way, although there are decisions of the Fee Appeal Committee. I am the bar representative on the Fee Appeal Committee. There aren't too many of those because they normally do get sorted out. Most of them relate to what is and isn't electronic evidence. I'll return to that briefly. And there's also a CPS fees bulletin, which is quite helpful when it comes out, although they normally only come out when there's been a change to the scheme. Next page, please. So these are the 12 top tips, and we'll deal with them one at a time, a little bit more detail on some than others. The point's already been made about this from the defence side. Sometimes the fee for one count on the indictment that looks like the minor or poxy offence will actually pay more because of the relevant page count that applies. So a lesser offence may reach an enhanced category when it wouldn't do as far as the more serious offence is concerned. So always check what appears to be the more minor offence, even if it's not in the enhanced category, may actually pay more. The second point, please. That's linked to the first point. The manual of guidance does not list every single offence that can appear on an indictment in the Crown Court. There are quite a lot missing, and indeed more recent offences brought in may well not be there. Always check, because the presumption is if it's not there, it'll be category H, but sometimes you can, and often indeed, persuade the CPS that that's the wrong category for this new offence. It is far more similar to a category B or some other type of offence, and that will make a difference. And that is obviously linked also to billing the wrong offence. We put up the third point, the start of the trial. I'm going to return to this. We'll look at the definition. I think too often advocates get frustrated with the definition, which is potentially problematic if a jury are discharged before any evidence has been called. And in long cases, you need to be very careful because there may be some days early on when there's a lot of toing and froing with legal argument or in relation to jury empanelment. Those days will count as the start of the trial if you end up calling some evidence. You just need a record of it, but I'll come back to that. Fourth point, multiple pleas. Now, this you have to be very careful about in multi-handed cases. You can only claim one cracked trial, so you have to potentially elect which is the better remunerated cracked trial. If you have an 8-defendant case, 3 plead guilty at the PTPH, that would be a guilty plea with an uplift for additional defendants. But if you have multiple guilty pleas on different days, you can claim those as multiple different guilty pleas, paying 40% of the main hearing fee. You can't do that with a cracked trial, though, so you will have to elect your favourite or most favourable cracked trial. But in that scenario I just came up with, you would be able to claim, say there were 3 different dates of the guilty pleas, you could claim 3 separate guilty plea fees, you could claim a cracked trial, single crack trial fee, and then the trial fee. So be very careful about how those are billed. Next, point 5, please. Similar in a way, multiple indictments. If an indictment is joined, it becomes one indictment. But if they're never joined, but are dealt with together, then there'll be an uplift paid. But if there are separate indictments to which separate guilty pleas are entered on separate days, for example, those will be separate cases. If they're dealt with on separate days, the sentencing hearing would be a single case with an uplift. So again, be very careful. There's a link here between points 4 and 5, just as there with points 1 and 2. Point 6 relates to not claiming for the unused. In a case that goes to trial, for example, a case of substance, certainly, it would be surprising if you hadn't had to do more than 3 hours work on the unused material. First of all, you should claim it. I know the hourly rate is low, but you should claim it for 2 reasons. One, you'll get paid more. Second of all, when it comes to any discussion in the future about unused material and payment for it, if you're not claiming it, it will be far more difficult to persuade the CPS that you're actually reading it to that level of detail. So everyone almost owes a duty to ensure that they're billing properly in relation to unused material. There's a link also to the defence scheme, because they talk to each other about whether the unused is being considered and how it's being considered. So going forward with future changes, it's critical that people are claiming for the unused material that they are reading and considering. Point 7, CCTV is not part of the main hearing fee in relation to the time spent. It is, for example, the 999 call or an interview under caution of a defendant. That's part of the main hearing fee. You can't claim for that, but you can claim for and be paid for CCTV. If it's the served CCTV, then you can claim for watching it. Obviously, if it's unused, then you could be claiming it in the unused section. Can we go to the next slide and then the remaining points? Point 8, similar point, not claiming for body-worn footage. If it is used footage, in other words, it's served as part of the case, you are entitled to claim it. If it's unused material, then again, you're entitled to claim it, but on a different route. And there can be cases where there is a very significant amount of body-worn footage. Indeed, often, sometimes, for a significant period of time. And if you have watched it, you are entitled to claim it, either as used or as unused. Point 9, ULS advices. I see this a lot as Treasury Counsel because we receive the advices from Prosecution Trial Counsel. Again, the rate is low, but you are entitled to be paid for that advice. And that advice should be detailed. I know they always come to you at the very last minute. You have to do it at the worst possible time in the middle of another trial, but you are entitled to be paid for that. Similarly, in relation to a rape acquittal advice. Point 10. This is similar to the defence scheme, but again, I think is missed a lot. If a hospital order with a restriction order is made, no matter how minor the offence is, you can claim as a category A. So you would be entitled to the same fee as if it was a murder case. That's a significant thing. There aren't obviously thousands of them, but there are quite a few that are imposed every year, and people often miss that. Point 11, bad character and hearsay notices. You will all know that pro forma type of notices are drafted by the CPS in many cases, and they're sufficient in some cases, but quite often they are not. And if they are not, or if you think that in fact you need to draft it on the particular facts of the case, then you are entitled to the fee for that. Again, relatively a limited amount, I'm afraid, but it all adds up when you look at all of the things that I've raised so far. And last of all, and just a small point, this is in the two advocate case, but sometimes a case comes to an end at pretty short notice. The case gets listed for mention, and then suddenly the defendant indicates that they're going to plead guilty. If it happens with absolutely no notice in a two counsel case, the CPS are normally quite sensible about that because that main hearing has gone. But if you're on notice of it, but one of you cannot get there, you ask in permission for as it were, advance permission not to be present, but still to be paid the hearing fee, because otherwise you're potentially going to get nothing in the case. And in a case of substance and significance, that could have a significant impact. So they're not the only ways to maximize your income, but those are 12 top tips, if I might say, which may assist you. Can we just go to the next slide and put all of it up for the definition of the start of a trial? I'm not going to go through this in significant detail. It's set out in the manual of guidance. In most cases, the start of the trial is easy. It happens on the day that everyone turns up for trial, the case is opened, and some evidence is called. But it is vital. It will not be a trial unless the jury is sworn and then evidence is called or read. It only needs to be one witness statement or one witness that's called or some admissions that are read, but you need both of those to be a trial. It doesn't, in fact, matter very much how long there is between any of those, as long as it properly is a trial. So the case needs to be listed for trial, and when as it were things are happening at the beginning, there needs to be meaningful progress. And that just means that you need to fill out a hearing record sheet to indicate that you went into court, there was legal argument about this particular issue on this day, and then the next day, and then on the next 2 days, we had to impanel the jury. That took this amount of time. And by then you might be 8 days into the trial. But unless you have that record of it, or the CPS have kept a record of it, you may get into difficulties. You shouldn't if you've got a record of it. And it's very important to look at the meaning of the trial, because we all know that there can be, in big cases, quite a significant gap between the trial starting as we know it and when you actually start calling the evidence. But providing there's a log, you'll be paid the main hearing fee, then the refreshers in the interim period. It matters sometimes for the defense scheme, as I understand it, whether a judge has said this is the first day of the trial. That doesn't matter a jot as far as the CPS is concerned. You need to look at what the manual of guidance says. Next slide. Okay, can we put all these up? Because I'm not going to go through the chronology, but you can look at this in due course. There is a series of steps that have to be taken if there is a dispute, and ultimately it ends up with step 8, determination by the appeal committee. I find, even in the cases that I deal with, that sometimes there are mistakes that are made by the CPS at an early stage of this proceeding when they send you the order to be flipped by your clerks. And then when we go back, they say, no, that isn't how it works. I always get straight on the front foot about that, point them to the manual of guidance, and normally within a matter of minutes, if not hours, it's all been sorted. If it hasn't been sorted, don't just stand back and go, oh, well, it's going to take quite a long time to sort this out. It will, as I've said, through these steps get escalated. And if you're right, then the reality is that it will get corrected in your favor. And as I've also said earlier, that will help others, because the people that were doing the initial assessment have got it wrong. And the best way for them to be informed that they've got it wrong is to be told that they've got it wrong, as it were, internally, as well as by us, rather than just letting it go. Ultimately, if it ends up, as I've said, in the appeal committee, that is a senior representative from the CPS, someone from the Attorney General's office, and me, and we assess those cases to determine who is right and who is wrong. And on a number of occasions, we have sided with the bar over the CPS. But I have to say, I haven't done one of those appeals for at least a year, if not longer than that now, mainly because these things do get resolved properly. Can we go to the next slide, please? And we can look at all the bullet points here. These are rare. They are a pain in the neck generally for the advocate. Certainly at trial, the VHCC scheme, the rates are still, I'm happy to say, I'm not happy to say, I'm unhappy to say, but I don't mind saying it, they're still far too low for this work. But that's something which I think is going to have to change. They were increased in 2023, but in real terms, they're appreciably lower than they were well before 2012. Only a limited amount of work needs to fall into that, and your clerks will be familiar with what you need to do. Just look out if your advocate is instructed, or you are instructed in a piece of high court work for the CPS. They're quite rare, but when they do, that has to be category 2 rather than category 3, no matter what its subject matter. And then last of all, can we just look at all those bullet points together? One, I think, of the significant frustrations, and this has been conveyed to the CPS, is the non-payment for the watching of the ABEs, because that counts mainly in sexual offences cases, but not just. And for me, that's an important change that I think needs to be made in the future. The discrepancy in the murder fees between the prosecution and the defence is, in my view, totally unjustifiable. That is in hand, but we are awaiting spending review decisions and the like. A very good example of that is the fact that if you prosecute a case that would be a 1.1 under the defence scheme, depending on the page count, the defence advocate could be being paid about 250% more on the brief fee the refreshers may be different. Now, I appreciate there may be other offences on the indictment that mean that that doesn't happen in every single one of those cases, but that is a discrepancy which is unjustifiable, and the prosecution fees need to be increased. The other thing we've asked for consideration about is the increasing demand for notes on sentence. That burden rests very heavily on the prosecutor rather than those who defend. They are time consuming. In multi offence and multi defendant sexual offences cases, those can take hours, and in fact are far more difficult than they may even be in many murder cases. That, in my view, is something which needs to be looked at. Other written evidence or other written work is a more complex issue. And there's the thorny definition of electronic evidence, which when it was originally defined didn't capture very much. Now it captures a significant amount, and that has to be paid at the moment often on an hourly rate. They will pay it, and you may have to spend tens, if not more than that, of hours doing it, but it is difficult and it's rare for that to be included within the PPE, and it's generally paid as well, at an hourly rate. That's a subject which there's been a lot of toing and froing about and may need to be looked at again in the future, but that's for another day. I think I will finish it there. Thank you very much.
Thank you very much, Tom. And all of the slides from our three speakers are going to be appearing, so circulated to those who've signed up. We now move to questions. We've got written questions in which we'll go through, and then also people have started to type in questions in the Q&A box. There's still time for you to type in questions there. Let's move to the written questions. Question number one, which I shall have a go at answering myself, and actually some of these questions people talk about the regulations and what the regulations say. When people have written in about that, what they're referring to, the document, is the Criminal Legal Aid Remuneration Regulations 2013 as amended. So if you were to type Criminal Legal Aid Remunerations Regulations 2013 into Google, it will take you to the legislation.gov.uk website, and then you can click on the button that says as amended, and then that will update all of the from all of the various amendment orders, and then you can see what the person's asking about. The first question is, with the upcoming changes from the Criminal Legal Aid Independent Review and any adjustments tied to the spending review, what practical steps do you recommend for Crown Court defence practitioners to ensure their graduated fee claims are robust and maximised? Now, looking to the future, what I've noticed in recent years, and actually if we go back, so 2013, when the graduated fee scheme was last had its major review, the purpose of a graduated fee scheme is, in theory, it's a mathematical formula. So category of offence, number of days of hearings, class of advocate, etc., all goes into the computer, and out comes your fee. And that's wonderful compared to the old system where you had to claim hourly rates and prove all the time you've done. So people welcomed a graduated fee scheme. But since 2013, the fees weren't increased by inflation. So barristers saying, well, no, my fees in real terms are like 40% lower than what they were. And the government, and trying not to get too political, government will say, oh, well, we haven't got the money to sort of increase your fees like that. What we'll do is we'll give you a little bit of money for the bits you're particularly unhappy about. So you can now claim for your unused material over 3 hours, etc. But that means that you're now having to keep work logs more than you did previously, because these extra little bits and pieces that the government are generously giving us require more work like that. So I think that Sir Christopher Bellamy, in his review, he was, for example, recommending the widening of the circumstances by which you can claim wasted in special preparation, which of course is a good thing, but it will mean that if that change were to come through, there would be more circumstances when you can claim, but more circumstances where you will need a worklog to evidence that claim. Question number 2, why does there seem to be such a reluctance to consider hourly rates on a discretionary basis when one is dealing with clients who have mental health issues? The work involved in such cases is often lengthy, and the remuneration does not seem to reflect the time needed to manage such cases. I think this might be one for you, Stephen.
Yeah, I'll have a go at answering that. So the issue we have is the way that the fee scheme is currently designed. There is no real mechanism to allow an hourly rate fee for mental health issues by themselves. So if we look at the special preparation fee scheme, there's two main mechanisms of how you can claim under that. Either your PP is over the threshold for the offence band in question on the indictment, or alternatively through the novel and unusual route. So when we get any claims, when it's looking at the additional work that's been caused by a defendant's mental health issues, normally it will come through on the novel and unusual route, but it doesn't really meet the criteria for that, unfortunately. So if we look at, for instance, the decision of R versus Priestley, which would be the one my colleagues in the CCUT would probably rely on if they weren't able to pay a situation like this, where that happened, it was the victim had a stroke. It was significantly difficult for the defence to get instructions from them. I've said the victim, sorry, I meant the defendant. It was really difficult for the defence to get instructions from them, and led to a large level of complexity, which completely understood. Unfortunately, though, when that was taken to a cost, they agreed that didn't really fall within the definition of novel or unusual, and there is no really currently any other mechanism for it to fall within. There is some other mechanisms upon which, where with some mental health issues, where you are able to maximize remuneration. Sarah touched on that in her presentation. If you have a defendant that's given a Section 41 restriction order, you can claim a band 1.3 for the offence class, and also if for sentence there is a hospital direction, a hospital order, or any restriction order, that sentence fee is paid at the rate of the refresher fee rather than a sentence fee. But unfortunately, the fee scheme doesn't have the mechanism within it to allow additional fees just for the work that's come from issues with the defendant. It's mental health, I'm afraid.
Thank you, Stephen. And I think, Tom, you mentioned in your presentation about hospital orders.
Yeah, so I mean that's the only way of there being any distinction for the inevitable work that goes in when there are a significant amount of psychiatric reports is if it's a case in which a restriction order is imposed, then you can claim at the same rate as if it was a murder.
Thank you. Next question, what to do when the representation order is unavailable, e.g. instructing solicitor is unresponsive or has ceased trading? I think this one for you again, Stephen.
Yeah, I'll take that. So a couple of options there. Firstly, we don't need a hard copy of the representation order. So if you have the MAT number, that's enough for you to put the claim in based on that. If you don't know the exact date that representation order is granted, if you can just advise us the date you think it was in and around that, we can then review it. We have access to those rep orders and can find that information at our end in tax on that basis. If you don't have the MAT number either, and in the example you've given, you're getting nowhere with the solicitor getting a copy of that rep order, it's in no one's interest to hold that bill up. We would like to get the money out to you. It doesn't do us any good if we don't pay that money quickly, because it can cause problems with us recovering final defence costs. So what you're more than welcome to do in that scenario, if the solicitor's not playing ball, is send an email to our advocates-fee inbox. I'll put that in the chat so everyone can see that. And if you could just provide us the URN or the case number, copy of the indictment, name of the trial advocate, and just ask, can we try and get the MAT number? We can search at our end, and if legal aid was granted, we should be able to find the MAT number and provide that to you, and then you can bill on that basis.
Thank you, Stephen. The next question I'm going to take myself, and it's from a law graduate who asks, how effective is a clerk and do we need one? I'm reminded of a warning from history of the case of LSC v Henthorne, and it is actually about when the Limitation Act applies in recoupments of civil legal aid payment on accounts. But there's and in that particular case, the barristers' clerks have been claiming the wrong legal aid rate in error. And the judge's judgment in this case explains where the barrister went wrong. The judge writes, she opened chambers with 2 other practicing barristers from her previous chambers. She appointed her son as her clerk. He had no experience of clerking barristers before he was appointed, neither received any training after appointment. The barrister had no involvement and had taken no interest in matters concerning her fees. Her clerks were poorly trained and had no clear idea as to the appropriate level of fees to charge. The melancholy truth is that Mrs. Henthorne may, through her clerks, have been the author of her own misfortune. So the questioner who asks, is it good to have a clerk? Yes, if you're thinking, oh, I'll set myself up as a sole practitioner, or set up a chambers and I'll have a clerk, that's fine. But make sure the person you appoint as a clerk joins the Institute of Barristers Clerks, does the training that they provide and the qualifications that they offer, so that you don't get into the unfortunate tangle that this barrister did in this case. So that's my recommendation. The next question is to do with the definition of a cracked trial. And the question is there any further guidance on trying to claim a cracked trial fee under Schedule 1, paragraph 1b of the regulations where say, quote, the case is listed for a trial without a hearing at which the assisted person enters a plea. The LEA have consistently rejected claims saying that the case isn't a cracked trial because the defendant hadn't entered a plea. I think this would be another one for you, Stephen.
Yeah, absolutely. That's one for me. Just before I go into it, I don't know if anyone can see my answer in the chat. I don't know if that can be kind of copied over to the question and answer, but I can't seem to add a question and answer, put the email address so that we can look at that in the background. But yeah, to answer that question, so let's delve into paragraph 1.1b of the regulations, because that is an area of contention between the LAA and the profession. I fully understand that. So we've had a lot of cost judge decisions recently, when I say recent, probably in the last 2-3 years, that shed a lot of light on what 1B actually should define. So their decisions like RV Barzi, RV Jarir, RV Morrison. There's a lot of others, but they're 3 of the main ones. So I think there's 2 questions of how you can interpret the cases listed for trial without a hearing at which the assisted person enters a plea. Is it that definition, either it means A, they never enter a plea, or does it mean B, they do enter a plea, but they enter it after the trial is listed? So that is the point that's been put forward, and cost judges have considered in quite a lot of depth. And the cost judge have come back and said it is a plea is never entered. Is their main position on that. It's not the scenario that you'll see a lot of the time, that there's an early hearing, the trial is listed, but for whatever reason, pleas can't be entered. Case goes 2-3 months down the line. Pleas are then entered at that point, which is the first time that they plead, and the trial conclude. The case concludes at that point. The prosecution accept that, and case is then sent off a sentence or whatever. So that's the position that the cost judge has taken. That is the definition, and I think that's quite a big disconnect between how we see the claims being claimed and how we have to assess it. There is obviously going to be grey areas within that, and there may be exceptions to the rule, but that's the main area of how it's assessed. A good question then would be, if that where then would that scenario actually occur, and where would you consider making payment under 1B of the paragraph. So there's two major scenarios where we would look at that. The first one would be if a trial was listed, no pleas were entered, then the defendant was to pass away. Clearly, then they can't enter a plea, that would fall within that. The major one, though, where you would see that falls was dealt with by Judge Leonard in the decision of R via Mugam. And they said they feel that definition is for cases where no plea is entered to the day of the trial. So on the day of trial is the first time that pleas are entered. They feel that that's where that definition is met, and that should be a crack trial in that circumstance, which we fully support and we would pay. So that's where where our position is, and those cost decisions are really interesting to have a read and sort of lay out the groundwork. Like I say, there may be the odd scenario where you get a grey area where we may pay a crack trial in those circumstances, but 99.9% of the time we're following those authorities, and that's how we're assessing.
Thank you, Stephen. And then I'm going to combine the next two questions. They're two long questions, but so you might want to people pick out bits from them, but they do overlap, so I'll read them both together. First question, in relation to Newton hearings, the guidance is not always clear-cut, and the views as to what makes a Newton or not, or a crack trial or not, can differ greatly between each case and between the LAA and council. And quite often we have to obtain emails from the courts to confirm things because attendance notes are not accepted, which is not always easy when the courts are busier and busier and court logs are not always up to date or complete. My question is, how can this type of query be more streamlined and the information on the logs which the LAA used to determine the claims be more transparent? Is there anything that us as clerks or counsel can do to assist with making things easier? And then the next question, which is related, there sometimes seems to be a disparity between what one determining officer determines and another in relation to things like Newton hearings, crack trials, stayed indictments, etc., or any claims that are just not clear cut. SFE, I think that's Secure File Exchange, is not the easiest package to use either. Some notes that are put back regarding a determination are very clear and helpful to us, but some are very sparse. Do the determining officers have the same way of doing it, or is it just different from person to person? It would help to understand the process so I can try and assist in providing what I need to limit rejections or soft rejects.
Yeah, so quite a lot there. I'll try and go through as much of that as I possibly can. So if we take maybe the second point first, and then I'll come back to the first one and try and tie into that. So I think firstly, I accept that there is discrepancies and there isn't the full level of consistency between the way our caseworkers assess things as I would like. I actually was involved in quite a large internal project that we were working on just before the cyber attack, where we were looking to collate a lot of data around our rejects, our redeterminations, our internal audit positions, lots of information to fully understand why we have some level of consistency issues. I mean, it is a complicated job in some of the areas. Not everything is black and white, so you will always have some degree of differences between where one determining officer may look at something very slightly different than another, and obviously everything's taken on a case by case basis. But I think we have to very much accept that the consistency level is not where I would like it to be, and it's something we are working on to understand. Unfortunately, the cyber attack, while billing crime was nowhere near affected like our colleagues in civil, we have had quite a large knock-on effect from it, and projects like that had to be put on pause. We're now over the summer months, so it is my intention to reintroduce that and start to fully try and understand where we're going on so we can improve, because we've got work we can do to improve, and I wouldn't want to shy away from that. more broadly, you're asking how we do we follow the same sort of principles? Yeah, we do. There's lots of work that goes on. Everyone will be given the same standard training package. We have a very intensive mentoring process for all of our caseworkers. We have some basic tick lists, but because of the complexity of the job in the case by case basis, they're not always fully they don't always translate over too well, but we have lots of other training packages, guidances, process maps. We have a really all of our senior caseworkers will take a shift where they are supporting our more junior staff. So we have a lot in place to try and get the consistency where we want it to be, but it's not as good as it could be, and we need to work on that. Going back to the more complex areas and what we could do to help. So I think you picked out the two areas that I would pick out within those questions, with around Newton hearings and state indictments. They are probably the two most tricky areas and that we find when we're trying to assess them as well. So to give a bit of an overview on both those areas that might help. So firstly, with Newtons, I would say that what I would call a standard Newton, where evidence is called, is pretty easy for us to assess off the court log. Where we have problems and where we find it more difficult is those cases that are more in line with the Hodder and McKengley decisions that I'm sure a lot of people on this call will know, where formal evidence is not called, but the judge is called to make a finding of fact, which is fundamentally affecting the sentence. The information that we get access to from HMCTS, we find that very difficult to be able to ascertain whether that is the case or not. I think if you look in the Hodder decision as well, the cost judge that dealt with that indicated the real complexity of that being possible from the LAA and how they only were able to do that by getting transcripts. So what can you do to help us with that? Give us as much information as you can at first port of call as to why you feel that it should fall within that, so we understand that why you're claiming that. That may end up being something that we still can't confirm from our system. What we do have, however, is a very small budget, which only a handful of more senior staff like myself have access to request transcripts for these cases where we're really struggling. Now, we would only do that generally at written reason stage, but we can do that. So what I would suggest is if we're in a logger jam on that specific issue, get it to written reasons as soon as possible. Explain to us in depth what the issue is, and what we'll do is we'll make that call if we can't confirm to go and ask the court, go and ask and get a copy of the transcript. As I'm sure you can imagine, it takes a lot of time to get that, but we will do that. We'll take the cost at our end because we know that that it's not cheap to do that. So that's an option you have open to you, but I'm not going to shy away that that's a difficult area and an area where we have a lot of complexity, and there's a lot of different cost judge decisions on that exact point in the last year or two, where a lot the LAA have won, but also a sizable number the council has won, and I think it shows you just the level of complexity that it has to be considered on a case by case basis, which is why we've gone down the route of trying to ask for transcripts where we can. I'll then just quickly come back to the state indictment question, because again, that's another area where we have a load of complexity. The thing you can do most to help us is to provide us a detailed breakdown at the start of why you're saying that these should be considered two separate fees. There's again a lot of cost judge decisions in the last couple of years that is shaping our viewpoint on that. The main thing that we're really looking for to be able to pay two fees there is we would want to see both copies of indictments on the original submission, and we want to understand what the specifically the major changes in the criminality between those indictments. So what you've seen, obviously, since the invention of the DCS is that they may make very minor changes, which then end up being quashed or stayed for administrative purposes. And the cost judges are leaning towards saying that they shouldn't be considered as two fees, but where they do push us to consider two fees are where there is a significant change in the criminality between the indictments. So you have to consider it in almost two separate cases. You have to really start again and do that work. So that's what we're looking for, to understand where that change in criminality came, and will give us the best opportunity of being able to assess that right first time.
Thank you very much, Stephen. We now move on to the questions that have come in online. We're going to race through these at a rate of speed. I'm hoping that Angela will let us run over by 5 minutes, but if the screen suddenly cuts out at 7 o'clock, then that wasn't possible. So first question, in interest of time, I'll answer myself. The question was, why can't the LAA pay the additional fee for the Section 28 hearing as well as a daily attendance fee if it's due, even if the advocate's not claimed it? We have had that sort of question before, similarly for the 1.5 hours for unused material that everyone's entitled to. You do have to press the buttons yourselves to claim the stuff. The LAA won't auto fill it in for you. So I'm sorry, you just have to be alert to it. Next question. In a sentence hearing, we received an analysis of 764 pages in Excel documents, summary of evidence and statements. The LAA are refusing to pay this Excel spreadsheet, and it was reviewed as legible on A3 as a sentencing summary. Does anyone want to have a go at finding out what might have happened there?
I mean, I can try. I mean, one thing I might suggest is this sounds like a very specific question. So if you want to email the advocate's inbox and mark it for my attention, I'm happy to review the specific case in depth or get one of my senior colleagues to do it. I think the question may be referring, though, to the scaling issue. So there has been a lot of cost judge decisions on on electronic evidence when it comes to how we consider Excel and what level of payment you should get per page of an A3 and A2 document. So that's taken on a case by case basis at our end, and I'd really need to know the case in more depth. But I think it may be referring to that, though the suggestion that we rejected it may lean towards that we don't, because we would normally make some degree of payment with scaling, but it may not be to the level that council is asking for. But yeah, I'm more than happy if whoever's raised that question wants to email that advocate's inbox, advise you've had this, you've been at the seminar, provide the case details, and I've suggested send it in, and I'll make sure that someone looks at that for you.
Thank you, Steve. The next one I'll answer, well, I will not answer, but it says, when are the legal aid rates for POCA, the Proceeds of Crime Act, going to be increased in line with the prosecution fees, as it appears to have been missed when the AGFS rates were increased in 2023? Well, we don't know when fee rates are going to increase, but we hope they will soon. And that is something actually when we can include in our detailed conversations. Next question. We've been told by clerks at another chambers that PTPH's, plea trial preparation hearings, can be claimed on defence billing as long as it's listed as a PTPH. We've searched the regulations and can't see this mentioned, but since finding out, we have been claiming all PTPHs as full PTPH fees and not as SAF standard appearance fees for ineffective PTPHs. Does anyone know what this question is about? And
yeah, I can take that one. That's fine. So yeah, it's a good question. There hasn't been a change to the regulations, is the short answer. And also there hasn't been a massive change to our interpretation, though I think this goes back to the point that's been made with the consistency point previously. We can pay a PTPH even if it is not what we would consider effective based on the listing alone. The reason for that is the regulations don't give a definition of a PTPH, so we would have nothing to directly fall back on that would indicate that we could assess it down to a standard appearance fee. So we tend to claim those pay those as they are claimed. If you claim it as a standard appearance fee, I could understand that, and we wouldn't argue with it, and we would pay it. But if you were to claim that as a plea and trial preparation hearing, we would pay that. One of the queries that may be linked to this is where there's been some confusion. That could be why you're saying it was more recent changes. There was some questions because for some reason on the common platform system, clerks were changing hearing types. So they were listed as a plea and trial preparation hearing. They changed it for a mention afterwards. And there was some question around whether we should pay that as a plea and trial preparation hearing, which I have discussed with our legal team, and we agree that we should. So they also can be claimed as a plea and trial preparation hearing.
Thank you, Stephen. The next question is for Tom. It says, regarding the first day of trial, I was certain that there had been a change to this in the last few years. It was agreed that the first day of trial would be paid as that, as long as it was listed as a trial. From recollection, the guidance had been amended to reflect this. If my recollection is correct, it appears we have regressed to the original position, i.e. jury must be sworn and evidence called.
We haven't regressed, and the recollection isn't entirely right. I understand what the recollection relates to. The definition has been expanded to make it easier not to fall foul of it being a trial. So it was amended a few years ago to our advantage, but that's the definition that I set out, the one that is to our advantage. The problem before used to be that the CPS would interpret the start of the trial as only being when the evidence started to be called if the jury had been sworn some days before, and that can't be right. Now the start is when it's listed for trial, but after that you then need those steps to occur for it to be a trial in the end. So you get paid for everything, providing some evidence gets called.
Thank you. And the next one's for Stephen or Sarah. Regarding unused and wasted preparation, long ago there was a general rule that the LAA would accept 2 minutes a page for witness statements and 1 minute for exhibits. Is this general rule of thumb still active in the experience of the speakers?
I'll try my best to answer that. That's dealt with by my colleagues in the criminal cases unit mainly, so I'm not an expert on it, but I have a reasonable understanding. Not particularly would be my take. My understanding from how our colleagues in the criminal cases unit would tend to assess these cases is they consider your submissions, they review the complexity of the case, and they may give a rough overview to a rough idea of statements and exhibit pages, but it's more based on the submissions. So apologies, it's not the best answer, but that's my understanding of how they do it. I don't know if Sarah wants to expand on that.
I've certainly seen claims rejected where people have referred to 2 minutes and 1 minute a page in their work logs or notes for taxation. So I wouldn't recommend making it explicit that that's how you've come to your calculations. My experience has been that the LAA want to see time spent against each item or each piece of work. So an overall calculation is not going to be accepted.
Thank you. Next question, what recommendations do you have to help pupils and newer tenants to start understanding the complexities of billing and for picking up tips to maximize billing apart from attending events like these?
Can I answer that from the CPS side, perhaps to start with? There is no alternative but to read the manual of guidance. It's pretty clearly drafted, and it won't take a particularly long amount of time, and everyone should read it and know it inside out and upside down.
I agree from the defence perspective as well. And also speak to your clerks. Speak to your clerks and find out what they need from you. They should be going through with new pupils and new tenants to chambers what they expect from their barristers in order to submit the bills. So yeah, just speak to your clerks as well as read the manual.
The only thing I would quickly add is that the LAA do have a training website where we put up quite a lot of webinars like this as well, and some of them may be of interest. I definitely know I've done some that are more aimed at newer, generally clerks actually than barristers, but I'm pretty sure there'll be stuff for newer barristers there as well. So that might be a route you want to look at.
Thank you. We'll carry on for another 5 minutes unless the screen suddenly cuts out. We're finding that the LAA are insistent on a physical representation order on the portal, as due to the data breach, they cannot access them. Is that correct?
I'll take that. So for a small period of time during the cyber attack, we were unable to access the physical rep orders. So we did for about 3 weeks have think about 3 or 4 weeks, late May, early June, we didn't have access to those rep orders. So we did soft reject at that point in time to ask if you had a copy so we could assess the bill. That system has long since returned, so we have access to it now. So for the only times we would ever really ask for it is we don't always get the appeals rep orders. So it's helpful if you provide appeals rep orders if you have it, and also breach rep orders if it's granted by the, especially by the court. We don't have access to that ourselves. But, your normal case on indictment, we can now see the representation orders. So you won't need to provide that a hard copy.
Thank you. Next question regarding the hospital order and the claim of 1.3. Is that only if the outcome is a hospital order? My client absconded at trial of issue and is unlikely to return.
Yeah, sadly, it's only if the restriction order under the Section 41 has actually been made. So yes, sadly, if it's not been made, we wouldn't be able to pay it.
Okay. Next question. Can a fee be claimed by an advocate attending a hearing as a witness in circumstances where they have become professionally embarrassed?
Not to my knowledge. I can't see how it would be allowed in the regulations. I've never seen that question before, but I'm pretty certain the answer has to be no. I can't see any way in the regs that we could allow it.
Yeah, I'd agree with that.
Thank you. Newton hearings make more difference to solicitors, and they may be more willing to request a transcript than counsel, especially as you will need the judge's factual findings. Any comment on that?
I mean, from our perspective, if you can get the solicitors to ask for a transcript and pay for it, we're not going to complain, and that may mean that it's there quicker and we can make the assessment quicker. So yeah, by all means do that. But obviously, if neither the solicitors or they don't want to do that, understand the cost. We can do it. We just won't do it until the written reason stage generally. So, and we'd only tend to do it on those ones where it's really unclear when we know that transcript would help us.
Thank you. If counsel prepares for a Section 28 hearing, but it does not go ahead, how do they claim for the preparation, specifically if they've had to do a significant amount to prepare?
There wouldn't really be any mechanism for that. So there's one Section 28 fee that is payable per case. It would be up to the barristers between themselves to decide how that's divvied up. So there wouldn't be any mechanism to pay anything beyond that. One point that is worth making, though, is if a Section 28 hearing is listed, it is still listed on the day, but for whatever hearing it can't proceed, that is payable as a trial not proceed based on our fee scheme. Again, I have seen the odd inconsistency where our caseworkers have assessed that down to a mention. If they do that, redetermine it, they're wrong. We have confirmed that with our legal team. It is definitely payable as a trial not proceed.
And then I think this is the last question. Client unfit to plead, set down for trial, entered guilty plea week before trial. Is that a crack?
Fitness to pleads are a bit of an anomaly, and it'd be one of the areas I would suggest people read the regulations and guidance on. But if there was a formal fitness hearing, then generally it's actually payable as a trial. So we can pay your one-day trial or a crack trial, which pay the same anyway. So that's a good area to read up on the regulations to understand. If they weren't formally found unfit, there is a Costeridge decision that states where there was a question around fitness to plead. Initially, that's why a plea wasn't taken at the PTPH, and then a couple of months down the line, they were found that there wasn't a fitness hearing, but it was agreed they were fit to plead, and they pled guilty. That didn't by itself meet the criteria for a correct trial. So it would all be case dependent. But if a formal fitness plea hearing takes place, you should be entitled to a one-day trial.
Thank you very much. We've just overrun only by 4 minutes, and I'm very grateful again to our 3 expert speakers. And then I think I just pause now while my colleague Angela in the background presses whatever buttons she needs to press to close the seminar. Thank you for everyone who has joined the seminar.